এবার আমি আহ্বান করছি শ্রী সৌমেন্দ্রনাথ মুখোপাধ্যায়, তিনি তার বক্তব্য রাখবেন।
Honorable Justice Pradipta Rai, Honorable Justice Raghunath Rai, and my good friend and mentor to some extent, Bikash Ranjan Bhattacharya. Ladies and gentlemen, wishing you all a very good afternoon. Sunday afternoon, just before lunch, may not be the right time to talk about or discuss fundamental rights. But as luck would have it, that's the time that has been allotted, and I shall try and keep it as simple as possible, considering that the majority of the audience are students. Before I start, I'd also like to apologize for not addressing in Bengali, and there are two reasons for that. I picked up law while practicing in the High Court, and the language used was English. I only read the Constitution in English, and most importantly, I learned Odia before Bengali, my mother being Odia. And Bikash Da has always been a supporter of mine as far as the exposition in Bengali is concerned. He's always encouraged me to speak in Bengali, but today I will disappoint him. So with that introduction, I hope I've woken some of you up to try and keep it light and humorous. But let's be clear about one thing. Today's topic for discussion is fairly open-ended. So my endeavor will be to focus on some aspects concerning the steps taken and that could be taken for the enforcement of fundamental rights efficiently by our constitutional courts. Now, the different areas that I will endeavor to highlight are, and I'm going to list them, there are 5. What are understood to be fundamental rights? Second, what are the provisions of the Constitution that deal with fundamental rights? Third, important interpretations by the Supreme Court of the what? Of the provisions in the Constitution that deal with fundamental rights. Fourth, and this is very important, some perceived failures of the Supreme Court in enforcing fundamental rights. And last but not the least, steps that should be taken by the judiciary itself to ensure effective enforcement of fundamental rights. So I come to the first point first. What is understood by the expression fundamental rights? Now, if any of you join the profession and you go to a chamber where the Constitution is discussed, you will find that there is an endless discourse and discussion on what fundamental rights are, and there never seems to be any agreement on this. The reason is actually twofold. Time-to-time interpretations of the Supreme Court as to what fundamental rights are, and second, academics and scholars expounding in a very complicated manner as to what fundamental rights are. Now, at the end of the day, it is important for every citizen and resident of India to know what fundamental rights are. And I don't think too many people have put it more aptly and succinctly than what Justice Chelameshwar did in the Puttaswamy case, which involved the right to privacy. So I'll just quote, and it's a fairly lengthy quote in the sense that it's 2 paragraphs. That's paragraph 353 and 355 of the Puttaswamy judgment as to what fundamental rights are. Now, Justice Chelameshwar says, all constitutions, apart from containing provisions for administration of the state, contains provisions specifying or identifying certain rights of citizens and even some of the rights of non-citizens. Both the classes of persons could be collectively referred to as subjects for the sake of convenience. Such rights came to be described as 1. Basic, 2. Primordial, 3. Inalienable or fundamental rights. What is the most important characteristic of a fundamental right? He goes on to say, such rights are a protective wall against state's power to destroy the liberty of the subjects. That is a phenomenal sentence. It is a right these are rights which are protective walls against state's power to destroy the liberty of the subjects. Irrespective of the nomenclature adopted in different countries, such rights are believed in all democratic countries to be rights which cannot be abridged or curtailed totally by ordinary legislation unless it is established that it is necessary to abridge or curtail those rights in the larger interest of society. Today, we should be looking at ourselves not simply as a welfare state, but as a rights-based society. We have rights. We must be able to enforce them. Several constitutions, then he goes on to say, several constitutions contain provisions stipulating various attendant conditions which any legislation intending to abridge such fundamental rights is required to comply with. These are what we call reasonable restrictions on fundamental rights. Then at the end, he goes on to say, the framers of a constitution believed that some of the rights enshrined in the constitution are more crucial, and please mark these words, more crucial to the pursuit of happiness of the people of India. Pursuit of happiness of the people of India, and therefore called them fundamental rights. I don't know how many of you have read Amartya Sen. I was a student of economics. Amartya Sen was a tremendous influence on us when we were students at Presidency. And he was also a tremendous influence at home. He was a friend of my parents. And for him, the most important aspect in economics and philosophy was to judge the happiness quotient of a nation. If the nation is happy, everything falls in place. And that's part of the Marxist view as well. I don't know if it actually ever works out that way. The belief is based on the study of human history and the constitution of other nations, which in turn are products of historical events. So what do we gain from this? Some rights are inalienable. Number one. Number two, they are the protective wall against state action seeking to deprive subjects of their liberty. And third, history is what teaches us what these rights should be. Because if you look back in time, the way power has been exercised over subjects, when we frame a constitution, we are thinking of protecting our subjects from that power. Because power can corrupt all, one and all. And if we can get protection from this, we will be happy. That's the happiness quotient, which is correlated to fundamental rights. Now this, by saying this, I'm just giving you a global view or a worldwide view, which Justice Chelameshwar really summarized in his judgment, in democratic nations as to what are fundamental rights. Now the next is, what are the provisions of the Constitution that deal with fundamental rights? Now I'm not going to elaborate in detail on that. It's to be found in part 3 of our Constitution. Basically, Articles 14 to 18 deal with the right to equality. That's equality before law, equal protection, prohibition of discrimination, equality of opportunity in public employment, abolition of untouchability, and abolition of titles. Then we have provisions that are described as right to freedom. The most important of these provisions is Article 19, which recognizes that a citizen, not a person, a citizen shall have the right to freedom of speech and expression, to assemble peaceably and without arms, to form associations or unions or cooperative societies, to move freely throughout the territory of India, to reside and settle in any part of India, and to practice any profession or carry on any occupation, trade, or business. Of course, they are subject to restrictions provided in Article 19 itself. Then we have Article 20, 21, 21A, and 22. Now here, the most important article is Article 21. Today, this is the article which is pressed into service by the courts more often than any other article. Earlier it was Article 14, in between it was Article 19, now Article 21 is the bulwark of our Constitution. Then Articles 23 and 24, you're all aware, prohibits human trafficking, forced labor, imposes a ban on child labor, etc. Article 25 deals with freedom of conscience and religious practice. Article 26 provides for autonomy of religious institutions. Article 27 prohibits state funding for religious promotion. And Article 28 prohibits religious instruction in state-funded schools. Now here, as a matter of interest, Mr. Bikash Ranjan Bhattacharjee and I have had to face off quite often, because his point has always been that you cannot have a grant to puja committees, because that is funding a religion. And I have had to argue that what is being done is to ensure, number one, that it's not really a religion which is being funded, but a festival which is being funded. And secondly, it is for the better administration of the festival. Till now I had won, but I don't think I'll be fighting against him again on this, because I'm out of office. Then Articles 29 and 30 provide for protection of cultural identity and language of minorities, and deals with rights of minorities to establish and administer educational institutions. Most recent case, all of you should remember, is the Aligarh Muslim University case. But what Dr. Ambedkar described as the heart and soul of the Constitution is Article 32. Because it provides a constitutional remedy for enforcement of fundamental rights in the Supreme Court itself. So we've got rid of the first two introductory chapters in this discourse or talk or lecture or whatever you want to call it. What in essence is a fundamental right and what are the provisions of the Constitution that provide for fundamental rights. Now I come to the third. And here Justice Raghunath Rai has dealt with the subject quite elaborately. That is important interpretations by the Supreme Court of the provisions in the Constitution dealing with fundamental rights. Now, if you look at the history of the Supreme Court on constitutional issues, and I'm not going to give you too many, any case law on it for that matter, you will find that from 1951, the interpretation is really by looking at the Constitution to have been written in black and white and giving a textual interpretation. But as the state machineries in the form of the executive and the legislature was perceived to be failing the nation, the judiciary embarked upon giving life, flesh and blood to the constitutional provisions which provide for fundamental rights. It was, in a sense, a schematic interpretation. Fundamental rights, the different provisions of fundamental rights were not seen as standalone provisions. They were seen in context to each other, and the interpretations, with some help from the directive principles, started being interpreted in favor of the citizen or the subject. So like Maneka Gandhi's case, it was held that the right to travel abroad is a right protected under the umbrella of Article 21. The right to life would also include the right to the basic necessities of life. Right to free legal aid was a right covered under Article 21. I'm not giving the cases, but I'm giving illustrations of the interpretations of the Supreme Court. A right to speedy trial was also recognized as an essential right under Article 21. Right to emergency medical aid was declared to be protected under Article 21. Right to shelter, clothing, decent accommodation, and clean environment was recognized as an element of right to life under Article 21. Right to education was recognized as an element of right to life. Now, of course, we have a separate provision in the Constitution. That's Article 21A, the right to education. Right to privacy. It's one of the lengthiest judgments of the Supreme Court. Was recognized as a right enshrined in Article 21 of the Constitution. Now, Article 21 has two expressions, life and liberty. Life has been intertwined with dignity. Liberty has been intertwined with meaningful liberty. To give to the citizens their fundamental rights. It's an interpretive exercise being carried out, And since Constitution is recognized as a living organism, it's probably importing into these provisions matters which the framers may not have thought of. But Constitution has to be malleable, it has to march with the times, it has to take into consideration the changes that are occurring in society. Now, apart from these interpretations, I just want to talk about a few important areas where the Supreme Court has had a role to play through interpretation again of various provisions of the Constitution involving fundamental rights. So I will deal with gender, religion, and access to justice. In 2014, the Supreme Court recognized the rights of the third gender. It was very important for our society. This was a gender which had all along been suppressed, was treated as taboo. But in urban and rural areas, you had the third gender. One by choice, one by nature. And that's what the Supreme Court realized and recognized, and held that discrimination on the basis of sex under Article 15 included discrimination on the basis of gender identity. Then we had Navtej Singh Johor's case. I hope that rings a bell amongst the students. It decriminalized homosexuality in India by reading down Section 377 of the Indian Penal Code, holding that the provision was discriminatory on the basis of sexual orientation and violated the right to life, dignity, and personal choice under Article 21. Then in Joseph Shine, which is in 2019, the Supreme Court held that Section 497 of the Indian Penal Code, which criminalized adultery, to be unconstitutional on the basis of its gender framing. Now, this is as far as gender justice and fundamental rights are concerned. I've just taken 3 cases, there are many more. Now, religion and courts. 2 cases I'll deal with. One is Shaira Bano, that unilateral triple talaq was unconstitutional, as it was an option only available to husbands, thereby violating Articles 14 and 15. Of course, legislation has followed later, making it a criminal act, and that's the subject matter of a challenge, constitutional challenge, which is pending in the Supreme Court. Here also, but Supreme Court had decided before us. Then you had the Sabrimala temple case. The court held that the right to freedom of religion under Article 25 is available to all, irrespective of gender, and therefore struck down the discriminatory practice of denying women entry into the temple, and held it was violative of 14, 15, 19, 1 and 21. Of course, there's a review which has been admitted against this judgment, which is pending. I might tell you there's another issue which is pending in the Supreme Court, and that is a Parsi woman who marries a non-Parsi, has children. Children are initiated into the Zoroastrian faith, but they have been denied the right to pray in the Ardha-Shatrans. There's also a challenge pending, both in the High Court and the Supreme Court on this issue. And the High Court is the Calcutta High Court, not Bombay. That's a matter which I'm doing. And As far as Parsis are concerned again, a Parsi girl who had married outside the Parsi community was not allowed to enter the Tower of Silence when her father's body was left to the vultures in the fire temple. Because many of us have cremation, many of us have burial, they leave it to the vultures in the Tower of Silence or the fire temple. That's also subject matter of challenge in the Supreme Court, relying on Sabrimala and Saira Banu. Now I come to another aspect which deals with the role of judiciary in access to justice. Now this has been recognized as a part of right to life under Article 21, and any denial of it has been held to be violative of Article 14 as well, because it denies equal protection and it is arbitrary. And the Supreme Court laid down 4 main facets of access to justice, which are, at the end of the day, if we want justice, if we are fighting, what do we want? We want an adjudicatory mechanism. That's the first aspect. It should be accessible. Only the Ambanis and Birlas should not have access to it, but the common man must have access to it. Third, and this is very important, and where in my respectful submission the judiciary is failing, speedy adjudication. And the fourth is that affordability of the adjudicatory process. So that would include not only lawyers' fees, but also court fees. How much paper do we need to file? Can we conduct an adjudicatory mechanism without having to travel long distances? On several matters, we should be encouraging video conferencing. Judges need to be trained on this. Lawyers need to be trained in this. And the last issue that I'm going to deal with on this chapter is the role of judiciary in providing compensation. So this has mainly been in environment, litigations relating to environment. Excuse me, ma'am, please sit down. Here, courts have held that not only can fundamental rights be enforced against the state or state instrumentalities, but it can also be invoked against private individuals who have acted in a manner that has violated the public trust doctrine. So one of the first cases where a private individual had to undo what he had done was Kamal Nath, a well-known politician, whose hotel between Raisan, in fact between Kulu and Manali, had interfered with the course of the Beas River. He was made not only to demolish the encroachments, but also pay compensation to ensure that the river found its course, as well as compensate the locals who had been adversely affected by reason of the change in course of the Beas brought about by his actions. The hotel is doing quite well now, after having taken care of this, but still there. Now I come to some perceived failures of the Supreme Court when enforcing fundamental rights. Most of you here may not have been around when the Bhopal gas tragedy occurred, but some of us were. Union Carbide had a plant in Bhopal which leaked poisonous gas, which resulted in several persons dying, and several persons and their descendants being impaired physically and mentally beyond imaginable proportions. So the Indian government decided to represent the case of those who had been harmed and went to the United States to get a large compensation. Failed to prosecute the case there, then came back to India and proceeded against a foreign corporation. It was an action and tort, but it found its way to the Supreme Court, where the Supreme Court encouraged a settlement. And a settlement was agreed upon between the government and Union Carbide on one condition, that none of their executives would be prosecuted. So for money, the Indian government gave up the right to prosecute those who were clearly culpable, possibly of murder. That was challenged later. But the challenge failed. In fact, one of the leading luminaries of the Supreme Court, who fought for Union Carbide then, said in an interview a few years before his death, Mr. Fali Nariman, if I had to live my life all over again as a lawyer and the brief came to me and I had foreknowledge of everything that later came in, I would certainly not have accepted the civil liability case which I did. The Supreme Court, when accepting the settlement, actually forgot the fundamental rights of the poor. Even today, the distribution is not over, and the waste, toxic waste, is still lying in Bhopal, still being removed at snail's pace. In fact, this decision clearly highlighted the court's failure to act as a check on executive overreach, and was perceived, and is still perceived, as a failure of the judiciary to protect citizens against authoritarianism. Then I come to the infamous case of ADM Jabalpur versus Shivkant Shukla, where the majority decision upheld the suspension of the right to move courts for enforcement of fundamental rights during the emergency. Specifically, it was held that Article 21 only exists as long as it is enforceable by law. So with one stroke of the pen, fundamental rights were wiped away, its enforcement was wiped away, and we had emergency. Today, yes.
So, just now you referred Union Carbide case and the role of the lawyer, the famous lawyer. I'm sorry, sir, in between actually it was so prophetic, that's why I just asked you. Was there any compulsion for the lawyer, or only for money he has done? Or if it is also, what was the role of the judiciary? We understand the limitation of the government, but what about the judiciary?
Correct, that's exactly what I'm saying. This is one of the disappointments of the judiciary. In fact, what I am talking about is where the Supreme Court has failed us in enforcement of fundamental rights.
So we are helpless, ultimately.
No, there's been a review, we failed, but we have to respect our system. We cannot, after all, our constitution provides for a system for redressal of wrongs. We are not anarchists. We have to accept that system. Judges are also human. Judges can err. We can criticize judgments, but we should not be cursing them and saying that they did it deliberately. We must give everybody the benefit of doubt. I've been wrong so many times. So many times. But it's never been with malice. Mr. Bhattacharya has also been wrong number of times. He admits it less often than I do. And the judges will be the first to admit that they have erred. And the redressal mechanism we have is to approach the higher authorities. Now, ultimately, the highest authority was the Supreme Court. You can have a review. After that, you can have a curative review. And if need be, legislation. Pointing out what the Supreme Court saw as a lacuna, addressing a lacuna which the Supreme Court saw, which permitted this kind of a decision to be passed, address it and have legislation. Legislation by itself can't per se override a judicial decision. There's a lacuna pointed out, you can fill the lacuna and have the legislation. So this is it. And I don't think Mr. Nariman would be doing it for money. I mean, I have known him for a long time, so have many of us. The standing that he had in the profession was because of his integrity. Not only him, his son as well, Justice Rohinton Nariman.
Sir, one thing
Yeah.
I would like to say, that out of this Union Carbide case, the enactment has become, that is,
Correct.
Public Liability Insurance Act.
Correct, absolutely. Correct. So that's what I said. That, correct. So absolutely. So now, that's what I said, legislation. So then it's ultimately legislation. We are talking about the judiciary here. We are talking about the judiciary. Yeah. So legislation has come. That's what I said. Ultimate, if it's not happening, if the state felt that things went wrong, sure, legislate. But legislate within your powers. ADM Jabalpur, of course, today is no longer there. Been expressly overruled in the Puttaswamy case, where in fact Justice Chandrachud went against his father. And then we have the internet shutdown case. The internet shutdown case is very interesting because it was decided after how many years? There was no meaning to it. Because when it was decided, internet had been restored in Jammu and Kashmir. For over a year, Jammu and Kashmir did not have internet. So it did not have access to the internet, and nor could the press disseminate information through the internet. So Anuradha Bhasin, who is a public-spirited individual, who had filed this case, succeeded but lost. And even today, you will find that several state governments shut down the internet. And they say they do it for security. West Bengal does it quite often. So does UP. Manipur. Absolutely. Now it's the last bit that I'm going to talk about. I think if I put people to sleep, can I have 5 minutes? Is that okay? Yeah. So, and here I look at it as steps that should be taken by the judiciary to ensure effective enforcement of fundamental rights. Now to start with, I'm the first one to admit that the judiciary is handicapped. Yes, because if you look at the number of vacancies, It is shocking. It is shocking. And I'm just giving you a perspective. In 1987, there are several perspectives on this, I'm not elaborating. 1987, the Law Commission recommended 50 judges per million people. That's per 10 lakh. The national average is far below. The national average is 14 judges per million people in what we refer to as subordinate courts. And in the high courts, which are constitutional courts and are to enforce fundamental rights, there are 0.6 judges per million people. Just imagine. Where are we on this? Is the state at all serious about dispensation of justice? And when I talk of state, I talk of both the executive at the center and the executive in the different states. They're not serious. Now, West Bengal figures are even worse. In the case of West Bengal, it is worse than the national average. There are 9.3 judges per million people in the subordinate courts, and not 0.6. 0.5 judges per million people in the High Court, of whom several are additional judges who are not being confirmed because they have not written judgments. Now, this is primarily because vacancies are not being filled up in time. And this is, when I say the judiciary really sat at a huge disadvantage when seeking to enforce fundamental rights, is this issue. Two issues I'm going to talk about through personal experience. When both the Justice Rayas were judges, they sat full time. Nowadays, there are several courts where judges in the Calcutta High Court sit between 11:30 to noon and rise by 1:15. Then again they sit at 2:30 and rise by 3:30 even if there is no full court. Now, this is a shocking state of affairs which the judiciary itself can remedy. Third, and this is also very sad, that where our High Court took the lead on constitutional matters, in several courts when a litigant is seeking to enforce a fundamental right or is seeking to challenge the validity of a central legislation, quite often the lawyer is asked, is this issue pending in any other court or any other high court? And if it is, he'll say yes. So let's wait for that decision. So immediately you are postponing decision making, you're ensuring rather that you'll never be seen as a premier high court. Now there are a whole lot of you youngsters here who I hope will take up litigation. It's the most exciting aspect in the study of law. That is the practice of law. And if you devote, and there's no substitute for hard work, you must remember that. So I'd welcome all of you to think seriously about the practice of law. But remember, there'll be more disappointments along the way than you could have imagined. But you will see life, you'll see the common man, You'll see the rich man, you'll see the poor man. You'll see the poor girl, you'll see the poor boy. You'll see discrimination at every level, but it'll make you a better human being. That's all that I have to say. I hope I didn't speak too long. Thank you very much.